Inside a tense Michigan courtroom, one defendant after another faces judgment. Each plea, each request inches closer to the breaking point. But one shocking denial leaves the entire room frozen in silence.
Court does call the case People versus Colin Sprry.
Ashley Feltus for the people.
This is about Defender Sandra White on behalf of Colin Sprry.
Your name?
Colin Joshua Sprry.
What are we doing?
Your Honor, we're asking for an adjournment. There was documents requested from CMH so that we can make a mitigation statement. I did receive a letter from them that they received our request. They did not indicate how long it would take them to.
You want the 18th or the 11th?
Let's try the 11th, Your Honor.
Probable cause conference will be adjourned to
Well, I mean,
September 11th, 2025, 9 a.m. Bond will continue.
thank you, Your Honor.
Thank you. Court does call the case of the People versus Derek Stevenson.
And Lori Gaggy, Assistant Public Defender, with and on behalf of Mr. Stevenson. Oh, sorry, could you say your name for the court?
He's waving.
He is, Your Honor, and you have an agreement from Ms. Willebring as to a plea in circuit court for with no DOC.
All right, you want to state that on the record then?
Yes, Your Honor. So I was in communication via email with Ms. Willebring about pleading a plea in circuit court and the COBs that we would be seeking that the people would not object to in circuit court would be no DOC. No specific amount in terms of jail time, though. That's to be determined, but specifically no DOC.
All right.
That's my understanding.
All right. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, I do, Your Honor.
People do also waive their right?
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
We would waive formal reading, Samuel.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
September 9th at 1:30 with Judge Cunkey.
September 9th, 2025, 1:30, Judge Cunkey. Bond continued. Court calls case of the People versus Sheena Stout.
And Your Honor, Constable Basin on behalf of Ms. Sheena Stout. Is approaching the podium to my right. Stout, can you state your full name for the record?
Sheena F. Stout.
There, today is the date and time set for probable cause conference. At this time, we're asking for an adjournment, and we're hoping that adjournment is on or past October 7th to coincide with the community corrections order that Judge Conkey gave her release to treatment at Bear River.
Is she going to Bear River?
Yes.
So
So
you need a date after October what?
October 7th.
2nd?
7th, Your Honor.
Without objection, probable cause conference, October 16th, 2025, that meeting. Bond will continue. Does she have a release to treatment out of this case?
I was going to ask for that, Your Honor, when appropriate.
Submit an order and get it in today so there's not a holdup when they're getting to Bear River.
Will do.
Thanks. October 17th.
16th. Okay, sir. Court calls the case People versus Devin Martinez.
People, Your Honor.
Yep. Just can't, oh.
Stephanie Cannon on behalf of Ms. Martinez. Ms. Martinez, could you please state your name for the record?
Devin Julia.
Your Honor, at this time, we are going to waive our right to a preliminary exam.
All right, is that correct?
Yeah, it's also address bond, for sure.
I will ask to address bond when appropriate.
Just making sure.
You're waiving your right to a preliminary examination, Ms. Martinez?
Yes, sir. Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Correct.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Agreed.
Do you understand that?
Yes, I agree. I understand. I agree.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Thank you, Your Honor. At this time, we will waive formal reading of the information and we stand mute as to charges.
Defendant having waived formal reading, standing mute as to both counts, court will enter not guilty plea. Pretrial will be set for.
From quiet adjournments to desperate pleas, the morning unfolds with routine calm. But when a trembling woman begs for release, the judge's tone changes, cold, unyielding. What happens next shatters every expectation of mercy in the courtroom.
September 8th at 1:30 with Judge Simpson.
September 8th, 2025, 1:30, Judge Hamud.
And Your Honor, as to bond.
As to bond.
Thank you. My client, when I met with her, I think Tuesday, she wanted me to let you know a series of things. One is she does have stable housing. If possible, she does want to be released to treatment at Spera for mental health and substance abuse.
Spera.
Yes, to Spera. She wanted me to ask in this case if we could get a 10% contingency on her bond, maybe 10,000, 10%. She wanted me to let you know that at the time she was on Ativan, she was in the middle of a psychosis. But for that, this would not have happened. She wanted me to let you know she's working for the government. She has a stable job.
I just want to really fast interject. It was the hospital that put me on Ativan as well. So for record, thank you so much. Sorry.
Nope, it's not a problem. And she wanted me to let you know that she has a cat. She lives with her fiance who needs her help with rent. Her wedding had to be postponed because of all of this. She has family support, her grandmother, dad, brother, mother, godmother, and friends. Your Honor, my client is just asking for the ability to be released. She understands that there will probably be a monetary amount associated with it, but she was hoping for 10,000, 10%.
What I'm going to do, I don't need a response. I'm familiar with this defendant. I'm going to deny your request. I will sign a release to inpatient treatment on a personal cognizance. So I'll sign an order to that effect. But this time I'm not going to release it.
And thank you, Your Honor. And I'll talk to you about what that means, Ms. Martinez. Thank you, Your Honor.
So yes, for technical purposes, I'm denying your request. However, I will sign that order.
Technical purposes are understood. Thank you. I appreciate you, Mr. Simpson.
All right, take care.
Good day.
Court does call the case, People versus Gary Taylor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Taylor, who approaches. Mr. Taylor, can you please state your name for the record?
Gary Taylor.
And Your Honor, unfortunately, I do know that I don't have all the discovery in these matters, so I'm going to have to ask for an adjournment.
Know that, right? There's also there's bond violation is why he's in custody at this point.
That's my understanding.
All right. We think can we get discovery cleared up in 2 weeks?
Yes, Your Honor.
All right. So I'll adjourn all of these cases to September 11, 2025, 9 a.m. Bond will continue.
All right, that'll allow us to redo that, okay?
Thank you. Rude.
I do my best, you know.
Well, court calls case, People versus Cody Wines.
That's supposed to be.
Belbisi.
Sorry. Assistant Public Defender Colin Sprry on behalf of Mr. Cody Wines, who's present to my right. Mr. Wines, could you state your full name for the record, please?
Cody Michael Wines.
At this time, we're respectfully requesting to set this for an exam.
discovery is complete.
To my knowledge, yes.
People have their witnesses available tonight.
Thank you.
Preliminary examination in person will be set September 9th, 2025 at 9 a.m. I'm sorry, before
Before you.
before me. I'm sorry. I don't know why I stopped at that point. I just did 9 a.m. before me on the 9th. Thank you, folks. Bye.
Thank you, Your Honor.
Today inside court, defendants tried everything: excuses, apologies, even emotional stories. But the judge kept full control, challenging every word and reminding everyone that justice can't be avoided. Watch closely because one shocking ruling changed the entire hearing in seconds.
Not signed in. I'll grant an adjournment.
Thank you.
He's fairly new to being admitted there, I think.
Yes. So I'm going to put it out a little bit to the 18th. Well, no, I'm going to put it 25th. And let's see exactly where he is.
9:25, Your Honor.
Adjusted. Yes.
I'll do a writ.
At 9 a.m.
Thank you, Your Honor. And I did reach out for what it's worth to the Forensic Center. I just hadn't heard back from them, unfortunately.
Okay. All right. Thank you.
Thank you for your lunch.
It's her.
Yeah.
He's not accepted back.
I don't know, I emailed him. These two are Spanish. This guy's gonna be in Zoom.
So, court does call the case People versus Robert Gillette.
Douglas for the people.
Assemble basically on behalf of Robert Gillette, who is present via the Washington County Jail by Zoom.
You're going to need to, oh, there we go. Okay,
And-
state your name.
Robert Gallett, also known as Lynn, sir.
All right.
Your Honor, I'm also standing in for Mr. Kilowald on this case, on the other matter. So we're asking.
Do you have any objection to Mr. Balbisi standing in for Mr. Kilowald?
No, sir,
Pardon?
not at all.
Okay.
Your Honor, we're going to be requesting an adjournment to confirm my client's getting into Avalon housing so we can continue negotiations for an offer.
Got it. So,
We have both I and Mr. Kilowald have reached out to Avalon to confirm the housing. We're yet to receive an answer. So we just need a brief adjournment.
September 11th, 2025, 9 a.m. Found continued.
Thank you so much, Judge.
It began like any other morning in court, measured, procedural, almost mechanical. One by one, the defendants stepped forward, their names echoing through the courtroom like ghosts, tethered to consequence. First came Colin Sprry, requesting more time to prepare a mitigation statement. His attorney's tone was steady, formal. The judge agreed to adjourn, extending a fragile lifeline to September. Sprry nodded quietly, the gavel granting him a few more weeks of borrowed time. Next, Derek Stevenson faced the bench. His voice trembled as he waived his right to a preliminary examination. The legal terms filled the air, no DOC, bound over to circuit court, but beneath the formality was something human, resignation. Stevenson's plea bargain offered no promise of freedom, only a delay before the inevitable reckoning. The courtroom's rhythm continued, unbroken, as though mercy had been measured and rationed. Then came Sheena Stout, her story heavier than the ones before. Her attorney requested an adjournment to align with a release to treatment order. The mention of Bear River and rehabilitation broke through the legal jargon, a faint light in the fog of criminal procedure. The judge agreed, allowing her to enter treatment, and for a moment, compassion glimmered on the record. But that glimmer faded when Devin Martinez approached. Her case, unlike the rest, burned with emotion. Her attorney spoke of mental health struggles, of medication-induced psychosis, of postponed weddings and family heartbreak. Martinez herself broke her silence, her voice shaking as she added details. The hospital, the medication, her fragile recovery. The courtroom stilled. Then came the turning point. The judge's tone hardened. "I'm familiar with this defendant," he said. The request for reduced bond was denied. No debate, no sympathy. Yet in an unexpected twist, he allowed a release to inpatient treatment, an act both merciful and firm. The tension in Martinez's face softened, though the denial still hung in the air. It was the kind of moment where hope and judgment collided head-on. As the session continued, Gary Taylor's case returned the courtroom to its usual rhythm. An adjournment was granted due to missing discovery, his bond to continue. The human stories faded back into paperwork and schedules. Then, Cody Wines requested an examination date, and the courtroom flowed through its motions again, predictable, procedural, yet thick with the residue of what had just unfolded. Finally, the case of Robert Gillette appearing via Zoom closed the session. His attorney requested more time to confirm housing placement.
The judge granted it without hesitation. And with that, the day's cascaded decisions came to a quiet end. Through it all, one pattern remained. Beneath the law's cold precision beat the pulse of human fragility. The defendants came seeking leniency, but justice demanded order. For every plea granted, another was denied. And as the judge's gavel fell one last time, the message was unmistakable. In this courtroom, mercy must earn its place beside consequence.